Okay. Mr. Slottje, am I pronouncing it correctly?
Yes. Mr. Supervisor, town board members, Madam Clerk, Mr. Superintendent, my name is David Slottje. I am Executive Director and Senior Attorney at Community Environmental Defense Council. We are a public interest law firm based in Tompkins County. I want to say at the outset that I am keenly aware that presenting to you is a privilege, not a right, and I want you to know that I very much appreciate and thank you for that privilege. I've got a PowerPoint tonight. I guess the first question. The first question I've got is.
I don't want to finish on your time.
No?
So anybody who wants to leave, we'll just let you leave now, so you're not interrupted. Everybody be here. One here.
Should I shoot there or shoot here?
Wherever you would like.
What's easiest for you guys? Here, probably?
There's
Okay.
What's up? Find a chair now.
Alex will bring it back as far as
You want to see the street?
No, I just want them to be able to see.
Okay.
okay, folks, we'll make it work. Get those who want to leave the club. There's only one switch and all the lights go out.
Sorry, I was looking for my remote here. There it is. I am not here to express an opinion on whether hydrofracking has been proven safe. I have an opinion, but that's not what I'm here to talk about. What I want to talk about is using the availability of local laws to protect high-impact uses such as gas drilling. I want to talk about the availability of a moratorium while the town considers its options. Should the town be interested, should the town board be interested. I want to bring you up to speed on the types of legal challenges to such protective measures that could be brought and that have been brought. And I'd like to give you our view of the risks of waiting to act. Before I start, to the extent that the gentleman in the Bill sweatshirt, I've got a Giant sweatshirt in my car, so you don't have to wear that. If you want me to go get it, I will.
Well, I'm wearing it because they didn't lose this weekend.
They didn't play this weekend. That's why Okay. Before we start, just very briefly, some people have asked whether the town, or any town for that matter, has the right to ban industrial uses, any industrial use, not just gas drilling. Over the years, the people at the Association of Towns have correctly told you, I'm sure, that you don't have the right to prohibit outright certain uses such as adult entertainment, the local dirty bookstore, as it were. And so people wonder whether, given those restrictions, whatever those laws are, also apply to banning heavy industrial uses. They don't. The legal rules that restrict municipalities from outlawing adult uses are very limited and very specific in nature, and they have to do with protection of constitutional rights, so-called First Amendment rights, free speech and freedom of association. But there's no question that exclusion of heavy industrial uses is a proper and legitimate use of local land use laws. The United States Supreme Court has said so repeatedly. So what I'd like to do very briefly is talk about whether the police power authority of New York local governments extends to land use matters. in a vacuum. We're not operating in a vacuum, but I will. Oh, and I'm sorry, I should have said this up front. To the extent that any of you would like a copy of this presentation, I'd be pleased to, if you'd like, I'd be pleased to send a copy, an electronic copy to the clerk, and if you'd like. So the police power authority is the authority of the town, this town, any town, to pass laws to safeguard the health, safety, and welfare of a town's residents, as well as to protect the property in the town. So the question becomes, does the police power authority extend to land use matters? And it does. The municipal home rule law, excuse me, I'm sorry, I'm addicted to this. The municipal home rule law specifically extends police power to and authorizes you to enact laws, again in a vacuum, I'll get to what I mean about in a vacuum, relating to the protection and enhancement of your physical and visual environment, as well as the protection, order, health, safety, and welfare of the people in the town. So that's in a vacuum, but we're not in a vacuum. There's something called the gas mining statute. The site, you don't need to write it down, like I said, I'll give you this. It's Environmental Conservation Law 230303 subsection 2. And the question is whether or not that gas mining statute takes away or preempts local authority to pass these kind of laws. I should have also said in the beginning that I typically do not like PowerPoint presentations because over the years I have found them, I've sat through more than I wanted to, and I've done more than I wanted to of them. And I think they're distracting, especially for the audience. But the reason I think they're good for this particular presentation is that, in my view, there's a lot of misinformation out there, especially about the law. And so what I think PowerPoint is good for is to actually put up the law and show people what the law says, not what some lawyer says or some non-lawyer says about the law, but what the law itself says and what judges say the law says, so people can make their own decision. So here's that gas mining statute I mentioned, the 230303 subsection 2. And what it says is that that authority that you otherwise have, that you have in a vacuum that I mentioned, does not exist. You may not pass laws, local laws, relating to the regulation of the oil, gas, and solution mining industries. You may not pass laws relating to the regulation of the oil, gas, and solution mining industries. You know what oil and gas are. Solution mining, if you don't know, is salt. So the question becomes, what does relating to the regulation of gas mining mean? In New York State, we all know that the United States Supreme Court is the highest court in the land. In New York State, the Supreme Court is not the highest court. In New York, the Supreme Court is the lowest court. It's a trial court. And the highest court is called the Court of Appeals. So when people are talking to you, not just on this, but about any issue about New York law, you might want your ears to prick up a little bit when they say Court of Appeals, because that's the end of the game. So, as to the issue of what does relating to the regulation of that language mean, the Court of Appeals has said unequivocally, repeatedly, and unanimously, albeit in a slightly different context that I'll describe, that the legal effect of language virtually identical to that gas mining statute language that I read to you is that while a town may not regulate the operations and processes of the particular industry which is the subject of that language, the town may prohibit the industry altogether using land use laws of general applicability. Now, by operations and processes, what they mean and what the cases say they mean is basically such matters as how far down they can drill, what formations, bonding requirements, and the like. So, this is a Court of Appeals case. Through run, was a unanimous decision of the Court of Appeals, construing language virtually identical to what I just showed you in the gas mining statute, but in the mineral mining statute context. In New York State, mineral mining, which is sand and gravel and topsoil essentially, is treated differently in as a statutory scheme than gas mining. But and the Court of Appeals has not yet had an opportunity, they will shortly as I'll explain, they have not yet had an opportunity to construe the gas mining statute language. But they have had numerous opportunities to construe that language in the context of mineral mining. And what they've said is that they do not interpret that phrase, local laws relating to the extractive industry, as including a town land use ordinance. That's the Court of Appeals, the highest court in the state. What they've said, again, unanimously, is that in order to determine whether you have authority to pass this kind of law, whether your authority has been preempted or not, you must distinguish between ordinances that regulate property uses and ordinances that regulate mining activities. If the ordinance regulates property uses, even if it touches the mining activities, as long as the focus is property uses, you are not preempted. That's Gernot Asphalt. It's a unanimous decision of the Court of Appeals. So, applying all traditional rules regarding statutory interpretation, that is the stuff that they teach us in law school about how we're supposed to figure out what a law really means. There's no reason why the language in the gas mining statute should be interpreted any differently when the Court of Appeals gets it than the language in the mineral mining statute. So the question is this a mainstream legal position? Yes, it is. It turns out that over the last year, this position has indeed become very mainstream, at least among neutral lawyers who have actually looked at the question and have an opinion. Just a couple of examples. In New York State, the large law firms, the 500 lawyer firms, the 1,500 lawyer firms, and so on, are all down in Manhattan. But in upstate where we live, the largest firm, or one of the largest firms, is Bond, Shennick & King. Bond, Shennick & King is an old firm, it's a large firm, it's a conservative and traditional firm. If there is ever an issue between the environment and industry, they are always on the side of industry. If there's ever a dispute between labor and management, they always represent management. Okay, that's the kind of firm they are. They have looked at this issue and issued a legal opinion. I should also tell you that when a lawyer gives a legal opinion, at least from the lawyer's perspective, it's not the same as when a non-lawyer says my opinion is X. When a lawyer gives a legal opinion, at least to the lawyer, that's a big deal. Because when a lawyer gives an opinion, you can sue that lawyer. So they've issued a legal opinion, it's about 6 months old now, and they're fancier than I am, so they say this in a lot fancier way than I did, but they're saying exactly what I said, that the author does not perceive any sound basis for believing that the gas mining preemption language will be construed any differently than the mineral mining statute. I'd like to talk about Whiteman, Osterman, and Hanna for a moment, too. Whiteman, Osterman, and Hanna is a good firm, a very good firm that's based in Albany. They're not as large or as old as Bond, Shennick & King, but they are a very respected firm. For many towns in upstate New York, Whiteman, Osterman, and Hanna was the education both for this mineral mining statute that I talked to you about and the fact that unconventional gas drilling was coming. Because about 2 years ago, Whiteman, Osterman, and Hanna grabbed a representative of an engineering firm based in Endicott, New York, called Delta Engineering, and they crisscrossed the state, upstate. They went every single place. It didn't matter if it was a town of 400 souls or the largest cities in upstate New York. They talked to the county governments. They went everywhere that would give them an appointment. And they went around to everybody, and they said, gas drilling's coming, it's terrible. Here's pictures of it from Pennsylvania. There is nothing you can do about it because of this gas mining law that I just showed you. The only thing you can do is road protection laws. Thanks for listening to me. And then they walked about 3/4 of the way to the door and said, by the way, we forgot to tell you we're selling road protection programs. Now, don't get me wrong, road protection programs are really important. But the reason I have this slide here is because Whiteman, Osterman, and Hanna now, despite having literally crisscrossed upstate New York, talking to everybody they could, telling them that local authority was preempted, does not believe that any longer. What I'm about to show you is a slide of theirs from last summer at an Association of Towns presentation in June. If you look in the box, you'll see that what their position is agrees with what I've told you. That when the Court of Appeals gets this, they will construe the preemption clause in the gas mining law the same way that it has already been construed in the mineral mining law. Now, as I said, this slide is 6 months old. It's from June. But I just, don't quote me, but 4 weeks, 3 weeks, I'm not sure ago, I did a presentation like this up in Albany. and I co-presented with a Whiteman, Osterman, and Hanna lawyer. And so as of 4 weeks ago, I can confirm to you that even though this slide is 6 months old, as of 4 weeks ago, this is in fact Whiteman, Osterman, and Hanna's position now. All right, now, you know about the Association of Towns. The Association of Towns has not taken a position pro or con about fracking, and they shouldn't. That's not what they do. They are evaluating next week the whole issue of home rule type issues, but their lawyer, their associate counsel, Michael Keneally, has spent a long time researching this issue. I have co-presented with him 5 times since August, and his position is what is my position, as I just explained to you. Here's his slide. Based on the existing case law, the courts are likely, at this time suits had not been filed, which I'll explain, but courts are likely, when they get it, to construe the preemption clause in the gas mining statute the same way as they did in the mineral mining statute. Okay? So that's Bonshenick and King, the largest firm in upstate, Whiteman Osterman, really good firm from Albany that went around and told all of us 2 years ago that you couldn't do this, and the Association of Towns lawyer. All right, we're going to skip this because you guys had a long comment period. So let's talk about what a police power-based law prohibiting certain uses might look like. It's simple. We basically just recite, our authority, what we're trying to protect, which is safety, prevention of increased traffic congestion, protection of rural and agricultural resources, preservation of our character, preservation of air quality, protection of water resources, and so on. And we just make it clear that what we're trying to do is aimed at minimizing or precluding adverse impacts on the town that could result from an inappropriate use of the property that might otherwise adversely affect others. I want to say one thing. I didn't say this up front, but in the event that you were interested in having a law like this, we would be happy to work with your existing lawyer, talk to that lawyer, spend as much time as you want, basically doing a brain dump with that lawyer, so that lawyer could get comfortable or not with everything we know, and then could advise you whether or not he or she agrees with what we're doing. Here is an example of how we draft things. I'm not going to go through this in a lot of detail on every clause of our agreements, but here's one of our definitions. It's basically natural gas wastes. And it starts as follows: any of the following in any form, whether or not such items have been accepted or exempted from the coverage of any federal or state environmental protection laws, or have been accepted from statutory or regulatory definitions of industrial waste, hazardous substances, hazardous materials, toxic substances, and so forth. Let me explain to you why we do it this way. The primary environmental protection laws in this country at the federal level, and some of the very important ones at the state level, all follow the same format generally. The laws basically have 3 components. The first component of these laws, or the first section, essentially, depending on what the law is, sets forth whatever materials or chemicals people are worried about. So they list xylene, toluene, and so forth. And then they go through at the bottom of that first section, and they say each of the foregoing is herein respectively called and collectively called, and then depending on what the law is, it'll say hazardous material, hazardous substance, and so forth. Then there's a second sentence, which I'll just skip for a second. Then they go to the third section, and the third section is basically saying any person holding, releasing, utilizing, touching, handling, so forth, and then whatever the law is, hazardous material, hazardous substance, and so forth, shall be subject to the following requirements. That second section that I skipped is 1 sentence, or depending on the law, 2 sentences. And what it says is, notwithstanding any provision hereof to the contrary, in the event that the person's handling, releasing, discharging, transporting, utilizing, etc., any of the foregoing compounds, chemicals, etc., is employed by anyone in the or associated with the oil and gas industry, then and in such event, those items shall not be considered to be and then whatever the law is, hazardous materials, hazardous substances, and so forth. So I couldn't make that up, if you think about that. So what the result of that is that if you did decide to protect a protective law, to enact a protective law, and then you tried to do the simple and clear thing, which is usually very good to go simple, and simply said, thou shalt not use hazardous materials or hazardous substances or whatever term you pick in our town, that would not be a good law. Because those people would say to you, even though it's xylene and toluene and whatever we're talking about, that if anybody else touched it would be hazardous materials, they're going to look at you and say, you can't go after me. I'm in the gas industry, so therefore, and when I use it, it is not a hazardous material. So that's why, if you decided to do something like this, whether we worked with you or whether we worked with your lawyer or whatever, that's why you'd end up with a longer document than you would be used to. Because we've got to do things specially like that because this is a special industry. So back to what these laws look like. There have been suggestions by some people that these laws would prohibit people from having the benefit of natural gas piped into their houses if that became an option, or would prevent people from barbecuing with propane if you passed a law like this. That's just not accurate. This is language that has appeared in virtually every single one of these laws that we have ever drafted. And what you see is that essentially the prohibitions say this law does not prevent the transmission of natural gas through utility lines to supply natural gas utility service to residents of or buildings located in the town. And this law does not prevent or prohibit, and then goes through the whole thing: lubricating oil, heating oil, gasoline, diesel, kerosene, and so on, in connection with legal agriculture, residential, business, commercial, and other uses within the town. So to the extent that there's any, I don't want to editorialize, but any sort of scare tactics that don't do this, we won't be able to barbecue, this sort of law does not do that. The other thing that this law does, or a law like this does, is it includes what's called a hardship exemption. And essentially anybody who believes that this law creates unnecessary hardship, and that's a term of art, that's a legal term, then in that event, the people who think that there's an unnecessary hardship have the ability, they've got a relief valve where they can go to the town board and essentially petition for a variance. You don't have zoning here, but in towns that have zoning, this functions the same way that a use variance functions in towns that have zoning. Moratorium, which is just the plural of moratorium. A moratorium is simply a stopgap or interim law designed to temporarily halt development while the town considers, among other things, comprehensive land use changes. The only difference, people say to me, what's the difference between a moratorium and a regular law? The only difference is that in a moratorium, well, there's two. In form, the only difference is that in a moratorium, there's a sunset provision or an expiry date, whatever you want to call it. It burns off. Some period of time, whatever you pick, whether it's 6 months or a year or 18 months, this law goes away without you doing anything. It can go away sooner, but if you do nothing, it burns off. So structurally, that's the only difference. Legally, the purpose of a moratorium, you can't just pass a moratorium. You can, but you shouldn't just pass a moratorium and do nothing. The point of a moratorium is to enable you to study something and accomplish something. If you know, for example, that you already want to make hotels illegal in your town, and you're afraid somebody's going to come in and put a hotel up, you put a moratorium, you can do that fairly quickly because you know what you need to do, and you are going to use that period of time, that moratorium time, simply to put a law that says you're not going to have any hotels. If you don't know yet, such as gas drilling, let's say that the town is undecided, let's say that some of the people, or that the town is divided, let's say some of the people on the board are themselves undecided. Let's say that you're waiting because you want to see what experts say, EPA or something. Then you need a slightly longer period for your moratorium because you're not just going right to drafting a law, you're using that period of time to study to see whether you need to do a law or not. All right. So, can't our town be challenged? What I've tried to show is that in a vacuum, You've got the authority to pass this kind of law. You're not in a vacuum. You've got the gas mining statute out there. Virtually everybody except gas lawyers believe that you're not preempted, that the gas mining statute does not preclude you from passing these kind of laws. 2 lawsuits have been filed along these lines, which I'm going to explain to you in a moment. One is in Dryden, which is Tompkins County, and one is Middlefield/Cooperstown. The Dryden suit, both of these involve towns that essentially passed land use laws. In that case, it was zoning amendments, but the same legal issue would apply with respect to moratorium that we're talking about. They passed zoning amendments that essentially made gas drilling illegal in the towns. In the Dryden case, a suit was filed by a gas company, Anschutz Drilling. And in the Middlefield case, the suit was filed by landowners. So you have both sides, both parties of a gas lease filing suit against the town. So, if you decided you wanted to get some breathing room and wanted to put a moratorium in place, could you be challenged? And what would those challenges be, those types of challenges? Well, the first type of challenge that usually comes up is that people might tell you, they usually do tell you, that it's un-American to tell people what to do with their property. I think the people who say that are acting in good faith, but that is just a mistake. Since before this country was formed, it's always been the case that private property ownership carried with it a responsibility that you not use that property in a way that somehow hurts your neighbors or hurts those downstream from you. That's been the law since before the country was formed, because that law actually comes from England. And it's been the law in England since before the Magna Carta, actually, back in 1066, which predates the Magna Carta by about 150 years. Okay. So, on that issue, it's important to know that every citizen holds her property subject to the reasonable exercise of police power. Court of Appeals, highest court of the state.
I'm sorry, just to interject.
Yep.
I don't know if Mr. Huderberg said that you were at 15 minutes on the agenda.
He didn't, I'm sorry.
I didn't know that.
Yes, you did.
I never
Yes, you did, Peter. I made a good point.
Stop.
So, well, you can.
All right, let me go.
I move that we allow him to continue.
Is the board okay with that?
I had no idea, I'm really sorry, I'll be very fast. So, property rights are always subject to limitations. Court of Appeals has said a person's ability to pursue what is otherwise lawful may be curtailed if this infringement is reasonably necessary for the common welfare. There's a question, sometimes people will say, you're depriving me of the highest and best use of my property if you do a law like this. Well, that's probably true, but according to the Court of Appeals, again, in a case that's almost 100 years old and still very good law, that's not an effective argument. The court noted that that's frequently the effect of police power regulation, and this underlined language I think is pretty important. The general welfare of the public is superior in importance to the financial profits of the individual. All right, this is tied for the most important slide in my presentation. Prevention of damage to others and community legally trumps the right to exploit natural resources. I mentioned to you that I co-presented with a Whiteman Osterman lawyer about a month ago. I went first, he saw this slide. I read this, which I'm going to read now, even though I have no time, but it's so important I want to read it. When I did read it, he whistled and said, "Whoo, that's powerful stuff." So you can laugh because lawyers are, amused easily, but this is a very powerful slide. A municipality is not obliged to permit the exploitation of any and all natural resources within the town as a permitted land use if limiting that use is a reasonable exercise of the police power to prevent damage to the rights of others and to promote the interests of the community as a whole. I'll move on right away, but that's Court of Appeals, unanimous decision, powerful stuff. That language, that case, is why virtually every lawyer who's looked at this agrees that when the Middlefield and Dryden suits get to the Court of Appeals, this is why those towns will win, because of this suit. This isn't some lower court case from Colorado. This is the highest court of our state saying this unanimously. All right, the other thing that we're going to talk about, we're going to say if you do this, it's going to be a taking. Taking's a very complicated area. There's two kinds of takings. I'm going to skip what I would normally do here and come back as we need it. But as the United States Supreme Court has noted, the notion that a property owner may establish a taking simply by showing that he's been denied the ability to exploit a property interest that he theretofore thought was available for development is just untenable. All right, so this is the $64,000 question. Should we wait until all of this gets sorted out? Should we wait until the Dryden lawsuit and the Middlefield lawsuit get to the Court of Appeals? That way we could minimize the risk that our town might have to spend taxpayer funds to defend the suit. Well, experienced lawyers agree that the final resolution of those two suits, which includes exhaustion of appeals, and all the lawyers in those cases have said no matter who wins below, we're going to go all the way up to the Court of Appeals. That whole process is 2 years. It's been in 6 months, so we have another 18 months to go. Everyone agrees that it's almost inconceivable that the DEC will not have begun to issue drilling permits by then. So waiting to pass a protective law until after the DEC begins issuing permits does two things. First of all, it deprives the town of the only protection for local control that the DEC has built into the draft SGICE, and that's the right to check that box that says a proposal to frack in town would be inconsistent with local land use laws. More importantly, we think waiting is not the financially prudent thing to do. We believe that waiting to pass a protective law until after permits issue actually exposes the town's taxpayers to hundreds of thousands or perhaps millions of dollars of liability, depending on the town, that does not exist, or at least would be dramatically lessened if the town passed this law before the DEC begins issuing permits. And I'll show you how and why. This is because bringing a successful regulatory taking lawsuit, a regulatory taking is a totally different animal than an eminent domain type taking. They might as well be almost separate animals. And bringing a successful regulatory taking lawsuit requires that the claimant prove that she had a reasonable investment-backed expectation. And I'll speed this up, but basically if this kind of law is passed before permits issue, they will not be able to successfully show that they had a reasonable investment-backed expectation. And I'm going to illustrate this, I hope, very clearly right now. I'll pick this up. It's really important to understand what the Dryden and Middlefield lawsuits are and are not about. Though both those lawsuits involve only a single issue. In a regular law, there's no such thing as a regular lawsuit, but typically in a lawsuit you have two things involved. You have facts and law. The fact part is, was the light yellow or red? Was it raining? Was it misty, etc.? That's the fact part, and then the law comes in. There's no facts to talk about in either one of these lawsuits, and there's only one legal issue. And that single legal issue is identical in both lawsuits, and that's whether a town has legal authority to pass this kind of law. In other words, whether that gas mining statute that I showed you preempts your local authority. This is the second most important, tied for number one slide in the presentation. Neither one of those two suits seeks a penny's worth of damages for the town for passing the law. That may or may not seem significant to you, but in each case, before the town passed those laws, people came in and pounded the table. They wouldn't have done it in this place, I see that. But they pounded the table and they said, what you do would be a taking. We're going to sue you for millions and millions and millions of dollars. They said that in both towns. For 3 weeks, 2.5 weeks before the Dryden suit was filed, the lawyer who filed that went on the radio. I listened to him. Every time he was on, you better believe I listened to him. And he told everybody, we're going to sue Dryden for millions and millions of dollars. The other thing you need to keep in mind is that when you're a lawyer and you are representing somebody who's been sued, you play the cards that were dealt you. You know, if they found your client with, cocaine in the car, you play the cards you got. When you bring a suit, you're called a plaintiff. And when you bring the suit, you get to pick the cards you want to play. In fact, you can even pick jokers sometimes. So you pick the strongest and best case you can do. Now in Dryden, this one brought by the fracking company, the lawyer here is a so-called super lawyer. If you go to his site, it says he's a super lawyer. That's basically, it's kind of a recommendation thing. He's a really good lawyer, and that tells you he's a really good lawyer. So he's a really good lawyer. He's a plaintiff, which means he gets to pick his cards, including jokers. His own papers, the papers he filed, the cards he played, specifically says that his client, the fracking company, spent $4.7 million on leases. But guess what? In that lawsuit, he's not alleging a taking, not for that $5 million or for any other amount. He doesn't seek a penny's worth of financial damages under any theory or claim, even though everybody went in and pounded the table and said we're going to sue, even though 2.5 weeks beforehand, when he went on radio and announced that he was going to file this suit, he kept saying, I'm going to sue for millions, I'm going to sue. So you look at what he actually did. His own papers, $4.7 million, he didn't sue for anything. The only thing that that suit seeks, and the only thing that the Cooperstown suit seeks, is to not a penny's worth of damages, is to overturn the town's right to pass the land use law. Now what that means is that win or lose, the town's downside in those cases is the cost of defense, or in other words, legal fees. And you know, that's a real thing, but it ain't millions, and it shouldn't be hundreds of thousands. The fact is there are very, very competent lawyers and law firms out there who are willing to defend towns like this, either for free or on a steeply discounted basis. There's two reasons they do that. Some of them are very angry. Not all gas companies are created equal. Some of them do a better job than others. Some of them are just terrible and terrible people, and I'll say that publicly. Some of them are good people. But there are some of these lawyers are very angry at some of these not so savory gas companies who have come in and bullied small towns. So that's why that group is willing to do something like this. The other group, frankly, is willing to do it for marketing reasons, because this is a very high-profile matter, and they would like to be in it. You may or may not approve of that. I don't personally, but I will tell you from a marketing standpoint, if you're going to take on a case for free like this, a high-profile case, you better believe that those people believe they're going to win. Because if they thought there was any doubt, I mean, that would be terrible marketing to say I'm going to do this for free and lose it. Okay, supporters of the, I'm almost done, and I'm really sorry, and I'm going to take it up with Mr. Hudeberg, believe me. Continue. Supporters of the fracking industry admit that part of the reason the lawsuits were filed was to have a chilling effect, that's the lawyer's own word from the radio, on the movement to enact town-level bans. What they don't tell you, however, is that they are at least as concerned about when a ban is enacted as whether the town enacts a ban. And that's for the reasons that I said. If you do it before permits issue, it's a totally different financial calculus than if you do it afterwards. You can still pass this kind of law, don't get me wrong, after permits issued. But if you do, you either have to essentially grandfather everybody who has gotten a permit in that period, or you have to write checks. So most towns couldn't afford to write checks, so they would end up letting the drilling take place. So, this is yours, sir. Is there any question that the cost of rebuilding even one road will be more than the money that the town might spend on lawyers if you do decide to use a paid lawyer instead of a free lawyer? That's it, and I'm really sorry I went over. One other thing. Since I meant what I said about this being a privilege to be here and being aware of it, since it was announced that I was going to be here, there has been a flurry of activity on the internet on the part of people who don't agree with the people who invited me here. You guys invited me, but the people. So they've sent around, there's about 3 different versions about questions that they told their people to ask in front of you. And they go out, they say things like, I flunked the bar 4 times. I don't know where this stuff comes from. That we get a bonus, depending on how many towns do something like this, bonus, bounty, reward. They, again, different emails, we call them different things. If we get, one of them says 50 towns, one of them says 100 towns, one of them says 1,000 towns. There aren't 1,000 towns in New York, by the way. One of them is supposed to be $100,000, one of them doesn't say. But anyway, what I've done here, oh, and then they say, ask him this. And I suspect one of the letters that you read at the beginning that just came in is one of those that came around. Ask him this, record what he says, blah, blah, blah. So I've taken the liberty of, I think you'll see it in one of your letters, exactly answering these questions. I have passed, I'm a member of 3 bars. I'm a member of Texas, Massachusetts, and New York. I was admitted in Texas in 1981. This is all in here. I was admitted in Massachusetts in '87. I was admitted in New York in 2010. Every bar exam I have taken, I have passed on the first try. All of this is here, it's all in writing. So if I could just put that in the record for each of you, that'll save some people some time on the internet. I'm here for your time, but you obviously, I went over, so I just want to thank you so much for giving me this time. And I really will take it out on Peter.
Does the board have any questions?
We just thank you for your presentation.
Thank you for listening, sincerely. Thank you.
The question, okay, in regards the use of the mining law, in that every case law that I saw up there cites a
Mineral mining.
mineral mining, all right, basically a local use, and none of them in support cite a gas with gas drilling or oil drilling.
Right.
Why not? Because of, I'm sorry, let me explain my point further, my question a little further. That one is really, is a local issue specifically. One is not just a statewide issue, because the product can go from here to Long Island, but can become a federal issue because it can go from here to Henry Howard.
Okay, so there's 2 questions in there. I will answer them in reverse order.
Okay.
You might need to remind me the first one. The second one is the law has already focused on that. The government has focused on that. And gas, natural gas does not become what you describe as a federal issue until it gets to be in transportation.
Correct.
Okay, so we're talking, it's not in transportation at the time we're talking about. The bigger issue, which actually comes up a lot, but has never come up and would never come up with a lawyer, that doesn't mean it's not worth coming up, it comes up all the time, right. But is why are you using mineral mining precedent for gas law? That's sort of your law. I mean, I'll get to it. First of all, the law we're talking about, the gas mining law, is pretty young. It's 1981. And this has never come up to the Court of Appeals. This is going to be the first time. That's why those lawyers want to do it for free. This is what the lawyers call a case of first impression. So that's why there is no precedent at that level that we can give you. The first question you asked, which is part of the second question I answered, is what you're really saying, from a lawyer's perspective, what you're saying is, not that you're challenging, but you're basically saying, I don't agree that it's appropriate to use mineral mining law as precedent in the absence of direct precedent, because mineral mining is different from gas mining, because the product, gas, is sort of more important. Is that the way to put it? Nationwide?
No, it's not. It's actually...
Or local. Okay.
Correct. Local versus
right.
a overall state
right.
lobby.
Right.
But like you said, is a differentiation of putting it into the transportation system.
Right. And with all due respect, and I mean that, usually when I say all due respect, I don't mean it. But I do here, I do. That's why I felt the need to correct myself, because it just comes out automatically. It means something else. But we believe that you are assuming your conclusion. That's an argument that the other side is trying to make at the last minute about this local issue. But the fact is, there's more gas out there everywhere than there is gravel. Gravel is more important. We can't walk out this door without gravel. We need it for roads, we need it for everything else. So I hear you, but we don't agree that that's...
But there was intent, legislative intent for the law in '81, according to, I believe his name was George Sovas, and who helped draft the law, that the legislative intent was to preempt local.
So here's the issue. Mr. Sovos was a DEC, or mineral and mining, you know,
Correct.
like a number 2 guy in DEC. And he basically says now that he essentially drafted this law, that he literally wrote this law with his pen, and that he knows what it says and what it was intended. So there's a whole bunch of legal issues that go with it. And in fact, there's an affidavit in the driving suit from Mr. Sovos as an exhibit on this issue. It basically says exactly what you said, as refined by what I said.
Right.
I wrote it. I know what it meant. You know, I wrote it. What I thought it meant governs. Well, a couple issues here.
Okay.
First of all, as a matter of law, even if he did write it, what he intended has nothing to do with the price of tea in China, as a matter of law. In fact, it's inadmissible. If lawyers could bet on legal stuff, which you can't, I would bet you all, I'd bet this room lunch, that the first thing that happens in that suit is that the Sovos thing gets thrown out as inadmissible. Because what the law says, Sovos, remember, in his capacity, was a member of the executive branch. And what the law says is what the executive branch says about what the legislative branch intended with a law is legally irrelevant.
And that's the one point.
That's a big point.
No, it is a big point because there was never, he never was forthcoming with anybody who was in the legislature to validate that.
So even if he did, even if there was somebody in the legislature, the fact is, even if this lady was in the legislature at the time and she was chairman of the committee that did the thing, and she liked Sovos and said, draft this for me, even her opinion wouldn't matter. But his opinion doesn't matter at all as a matter of law. Okay. Secondly, and this is really important, and this will come up in the lawsuit, about 15 years ago, Sovos took exactly, he was being paid by different people, took exactly a 180-degree different position on this issue. Okay? So now, write that down, this is, okay?
Yeah.
Thirdly, remember I told you, I showed a slide that said about rules of statutory interpretation that every single lawyer agrees with? Mm-hmm. What those rules do, which I have done, is there's something, when you pass a bill in Albany, there's something called a book jacket, and a bill jacket rather. And before the governor signs a bill, it doesn't matter if it's a tax bill, a gas bill, it doesn't matter what it is. It can be about cars, anything. Virtually every department in the state has to send a memo to, not really the governor, but whoever is sort of the governor's, you know, main executive secretary person. Can't remember what it's called. And each one of those has to say, you know, we don't have a problem with this. The tax people, we don't have a problem with it. The car people, anybody who governs anything. You go to that bill jacket and it's in there.
It's recorded in the Department of State.
Pardon? Yes.
Yes.
And that's with the Department of State. And that is the definitive, unless there is history, legislative history in the Act, which there is not here. The bill jacket, believe me, I'm up to speed on this.
Yeah.
The bill jacket is the definitive record, or absence thereof, as to legislative intent. And the way those rules work about legislative intent, it's kind of like in the NFL, where unless there's whatever the term is, sufficient to turn it over, there ain't nothing here that would support in a million years what Sovos is saying.
I agree. I've never found anything.
Okay? Sorry to be so excited about that. Anything else?
There were other decisions in the past that regarding gas mining.
There's only one decision. It's
in
called,
New York State. Okay.
Yes, I'm sorry.
Yeah, right.
Well, this is really, I'm not talking to them.
No,
this is really important because the law in Pennsylvania is very different from the law in New York. The law in West Virginia is very different. So when you get an email that says, Pennsylvania did this, like in Pennsylvania, it's a constitutional requirement that they are allowed to drill somewhere in every town. That's not the law here. Okay? West Virginia is a different area. In West Virginia, there's basically no, what we call home rule, no statutory authority. basically, you work in West Virginia, you work for the government, basically, as far as. So West Virginia precedent, Pennsylvania precedent, no. And there's only one recorded case at all in the gas mining statute at all, at any level. It's lower courts, called Keatone. And that doesn't say anything. It just, from our perspective, all that says is what I said, because that was a bonding requirement case. And the law has always been crystal clear that a bonding requirement is operations and processes. Thank you again, and again, sincere apologies.
Thank you very much.
Thanks.
Any other questions from the board? No. I have one.
Yes, sir.
Are you the head of the firm, Community Environmental Defense Council?
Yes, our firm is very large. It's my wife and me. So if she was here.
So you work with towns that, to help them draft legislation?
If they know what they want to do, if you say we want to protect the law, we will give you your options like we did here, and we will give suggested drafts, but yes.
And that's at no cost to them?
Oh, I'm sorry, pro bono, which means free. One of the questions that comes up that I forgot to put on that little squib is they won't stand behind their law and defend. We will stand behind our law and defend. The issue, which I don't want to go into in detail, but I would be pleased to talk about in an executive session, because I don't think it's prudent to talk about selection of counsel in front of people who might be the ones who tonight told you they're going to sue you. But we absolutely do. There's some issues you should be aware of about what our experience is in basically very, I don't want to go more than, in a smaller market, the lawyers do everything. So the same person might do a will, who does a divorce, who does a house close. In a larger market, my entire career has been in really large firms in really large cities. In a larger market, you specialize. It's not even just like this guy's a foot doctor and she's an arm doctor. It's really like he's a left foot doctor and she's a right foot doctor. It really is that level. So I would want to make sure that you understood, and our experience is not in litigation. So I would want to make sure that you, and I always make sure that every town we work with understands what we've done, what we didn't do. Even if we picked, or you picked a litigator who you had confidence in or whatever, we would still do free, all the research, all the, carry the person's briefcase, whatever, which would save you a ton of money. Then you're just having somebody who knows, litigation rules, which we don't. So what happened is that early on, somebody said, would you defend this town for free? And I started going in just like I did now. We're not litigators, so they took that and said, okay, they won't defend their laws. So now I just say yes. And then when I get into private session, I say, well, but we're not litigators. We can do all the research, we can write the briefs, but that's where that little nugget that's out there came from that says we don't stand by our laws. I just, you don't want, I've been practicing 31 years, despite what they say that I haven't. But not in court. So, we would want real litigators in court. Thank you.
Thanks. Thank you very much.